hearing officer for the Colorado Department of Transportation, which we will refer to as the department or CDOT. Today is Thursday, July 17th, 2025. It is now 3:31 p.m. And this is a permanent rulemaking hearing pursuant to the Administrative Procedure Act found in Section 24.4.103 of the Colorado Revised Statutes to hear oral testimony concerning the rules governing the automated vehicle identification system in the enforcement of traffic laws. During this rulemaking hearing, we refer to these administrative rules as the rules. This hearing is being conducted virtually through Zoom. The hearing is being recorded, and the recording will be retained at CDOT. I'm presiding over this permanent rulemaking hearing based on a delegation of authority from the Office of Transportation Safety under CDOT's Office of the Executive Director. Section 42.4.110.5 of the Colorado Revised Statutes authorizes CDOT's Office of Transportation Safety to create these rules. Here with us today from CDOT are the Acting Director, Executive Director of CDOT, Sally Chaffee, Deputy Director Herman Stockinger, Rules Advisor Amber Paolo Emilio, and I believe Chief Engineer Keith Stefanik. Representatives from the Attorney General's office are also here with us. I'm now going to walk through the hearing agenda so that you know what to expect. CDOT staff Amber Paolo Emilio will give a brief introduction, and then we'll establish how CDOT has met all the procedural requirements required by the Administrative Procedures Act. Then Amber will give a short presentation on the proposed rule, and after that, participants will have the opportunity to give verbal comments. Finally, I will make a finding as to whether or not the rulemaking proceeding, including this hearing, was conducted in compliance with the Administrative Procedure Act. I will prepare a complete record of the hearing and forward the record in the proposed rule to the Director of the Office of Transportation Safety for final consideration and approval. This record will be kept on file with CDOT's permanent rulemaking records. Okay, let's start with an introduction from our CDOT Rules Advisor, Amber.
Hi, everyone. My name is Amber Palomilio. I am the CDOT Rules, Policies, and Procedures Advisor and the Rules Administrator for these rules. In 2024, new subsections of 42.4.110.5 of the Colorado Revised Code were enacted. The statute now gives CDOT the authority to make new rules to create and manage the use of automated vehicle identification systems on state and federal highways located in Colorado. The statute makes CDOT the legal authority for the rulemaking, which means the Office of the Executive Director here at CDOT must have final approval and will sign these rules. Thank you so much for everyone for being here for today and for being a part of this important process. I'm now going to establish that CDOT has met all the procedural requirements by the Administrative Procedure Act, and then I will give a presentation on the substance of this new rule. The Administrative Procedure Act has requirements to ensure that the public is properly notified of proposed rules and has an opportunity to provide input on the rules. I will briefly summarize the steps we took to meet these requirements. All documentation has been provided to the hearing officer. It's also posted on our proposed rule webpage, and it will be retained in a permanent rulemaking file here at CDOT. On June 13th, 2025, CDOT filed the proposed permanent rule and notice of rulemaking with the Secretary of State, which included the hearing date, time, and the Zoom link for this hearing. We began accepting written comments on June 15th, 2025. CDOT also filed the proposed permanent rules and hearing information with the Department of Regulatory Agencies, which is also called DORA. This triggered an email to the members of the public who have signed up on the DORA website to be notified of any CDOT or transportation-related rulemaking. CDOT also sent emails with the proposed rules and notice of the hearing to two groups. This is our stakeholder group and our interested party group, which consists of anyone who has notified CDOT directly that they want to be notified of CDOT rulemaking. Our public notice of the rule was published in the Colorado Register on June 25th, 2025. As today is July 17th, 2025, we've met the requirement to hold our hearing no earlier than 20 days after that notice was published. Finally, on July 7th, the Secretary of State notified CDOT that no public cost benefit analysis was requested for this rule. I will provide all these exhibits to the office of the chief engineer and the executive director, and I will maintain the entire permanent public rulemaking record here at CDOT. I would offer all the hearing exhibits today into the record for your consideration, Andrew. I would ask for permission to correct any Scrivener's errors in the rules document, should that be necessary, prior to presenting them to the executive director for consideration and adoption. I would also ask that you find that all statutory requirements of the Administrative Procedure Act have been met at the end of this public hearing. Thank you.
Thank you. The exhibits have been entered into the record, and Amber will now explain the substance of these proposed rules.
Okay. Can folks see my screen?
Yes, for me.
Yes.
We can see it, but can you do it as the full screen? Yeah, there you go.
All right. So this is about the substance of the rule itself, the automated vehicle speed identification system in the enforcement of traffic law. Like I mentioned earlier, as part of SB 24-195, which was called Vulnerable Road Users, the General Assembly amended 42.4.110.5 CRS, which is the Automated Vehicle Identification System Code. So now this law requires, among a bunch of other things, for CDOT to create the rules that we've drafted to govern the administration of a statewide AVIS program. The statute requires that these rules contain prioritization criteria that we will use to determine which local entity is authorized to use an AVIS if multiple entities end up seeking to use it on the same area. It will outline, or the rules outline, the process that the department will use to notify a city and county, or municipality that the state will be using an AVIS within its jurisdiction. Establish the amount of civil penalty imposed for traffic violations detected through CDOT's use of AVIS. And it establishes the administrative and enforcement process that we will use to administer, hear, and resolve traffic violations detected through the use by the Department of AVIS, including the administrative hearing process. The rules were drafted and reviewed by CDOT and then the Colorado Office of the Attorney General. Once the rules are finalized, they'll be made effective when the CDOT executive director signs them. And the new program will be managed by Traffic Safety and Engineering here at CDOT, and the contact is here on these slides. And these will be posted. They'll be part of the recording and they'll be posted as well. So what are the purpose of the rules? The rules govern CDOT's use of AVIS on state and U.S. highways, and like I mentioned, the administrative process that meet the section of the statute. What do the rules actually do? They establish the amount of civil penalty imposed for traffic violation detected through the use of AVIS. They outline the warning period for notices of AVIS. I just saw that someone's trying to be let in, so let me fix that. Okay. Can we still see?
Yes.
Okay. Okay, so they established the amount of civil penalties imposed for these traffic violations. Those of you that just joined, sorry for the delay. I'm going over what the rules actually do. And this is all recorded and the slides will be posted as well. The rules outline the warning period for notices of violations. They contain the requirements for what must be included by law in those notices of violations that are sent out, or the civil penalty assessment. They establish the administrative and the enforcement process that CDOT will use to administer, hear, and resolve a traffic violation detected through that use of AVIS. And it also includes the administrative hearing process. The rules do outline the prioritization criteria that we will use to determine which entity is authorized to use if multiple entities seek authorization for use of an AVIS. It establishes the collection process for unpaid notices of violations or unpaid civil penalty assessments. And I do want to note, and this is required by statute, nothing in these rules apply to the use of AVIS for the purpose of collecting tolls, fees, or civil penalty in accordance with the Public Highway Authority law and toll highways. Does anyone have any questions? And go ahead and use the raise hand feature if you do. All right, I'm not seeing any, Andrew, so I'll pass it back off to you.
Great, thank you, Amber. All right, well, at this time, we will start with the testimony phase of the rulemaking hearing. My understanding is that at the time of the meeting, we did not have any members of the public sign up in advance to testify. Is that correct? Okay. So then, is there anyone currently on the video now who would wish to make a comment? If so, the raised hand feature is available. Please raise your hand and we will call on you in order. If anyone would like to comment now at this time about the rules. Amber, I'm not seeing anyone, any hands raised. Am I missing anything?
I see
Oh,
one
Sheila.
hand.
Yes, Sheila. Do you want to go ahead and unmute yourself and go ahead and make your comment? You have 3 minutes.
Yes, I do. Okay, thank you. Yeah, I was the one. This is Rep Sheila Leader representing Littleton, Lakewood, and a slice of Morrison. You just now let me in, so I didn't hear any of the beginning part of the presentation. So I'm glad to hear that they'll be coming out. But I did have a question. I assume you're talking about the cameras and the speed cameras. I do have a question of where are these cameras manufactured at?
If anyone on the call knows, feel free to answer. And if not, Rep. Lieber, I'm happy to try and get that information for you.
Yeah, mainly are they manufactured in the U.S.?
Amber, this is Keith Stepanek, Chief Engineer. I don't have that information available at this point in time on where the cameras are manufactured, but we can find out.
Okay, thank you.
Thank you. Just a reminder, as we're opening up this forum for comments, please limit comments to these proposed rules. And if you would, please state your full name and identify any organization that you're representing. Obviously, the purpose of this hearing is to receive your public testimony, and the focus is on the public. However, as in that case, CDOT staff may step in to clarify something that might have been misunderstood or to answer a question. Other raised hands, I see Veronica. Please go ahead, Veronica.
Hi, this is Veronica Sun with the City of Boulder. I'm not sure if this is the right time, but I had a few clarifying questions on the CCR. Should I be asking all the questions I have now, or should I just reach out post-meeting?
Do you want to float one question now and see how we do? If this is the right,
Sure.
if this is the right forum for that, we'll find out.
I guess first question was on the definition on deployment. It says deploy means utilizing AVIS within a designated corridor, and it does not include moving or relocating or securing an AVIS within an established designated corridor. The City of Boulder has both permanent cameras and speed cameras, and we were wanting to clarify what that definition meant by it does not include moving or relocating.
So I can take that, Andrew, if that's okay with you.
Please.
Yeah, thanks, Veronica. First, I want to clarify that these rules only apply to CDOT's use of AVIS on state highways, not any other municipalities or localities, unless 2 localities are applying for use of an AVIS on a state highway, and we're determining who gets that use. In terms of why the definition is written in the way that it is because statute requires us to give public warning notice when AVIS is deployed or installed. And so because when they're already set up in a corridor, they may be moved within that corridor, but that's not a new installation. So that's the reason we've defined it that way. I hope that's helpful.
Okay, yeah, that's helpful. So we have a few on state highways, and so we wanted to confirm that we are able to move our photo radar vans once they are approved. Should I continue on with my questions I am totally fine reaching out after the meeting too. They're very similar
Yeah.
questions to these.
I believe we have time if you'd like to continue.
Okay. Second question is on notice of violations. It says notice of violation means the notice issued to the responsible party. We wanted clarification on the wording of responsible party. I know there's a definition that says responsible party means the registered owner, but the city of Boulder was getting a little confused since there's registered owner, responsible party, and liable party. Is the definition on the CCR when we say responsible parties basically the same as registered owner?
So I can take that one too,
Okay.
Andrew. That's a really good question, Veronica. So it's responsible party for the purposes of these rules. So nowhere else, but for the purposes of these rules, they're defined as they are. So which, yes, includes registered owner, but it's not always just the registered owner of the vehicle.
Awesome, thank you. Next question. On the section for warning period and warning notices, it says only one warning period or warning notice may be sent. Is it okay if we do a minimum of one warning rather than just only one? The city of Boulder sends out a warning notice for every single violation that is done throughout that month period. And we wanted to confirm that was an okay thing to do even for CDOT corridors.
Amber, you want to take that one as well?
Yeah, I think that's fine. That's fine to do, Veronica.
Awesome. Making this
Thank you.
really
Thank
easy.
you for asking.
Let's see. Next question. There's an admin procedure section. It says the department shall provide the responsible party with all photographs, maps, and other evidence that the department intends to use to prove the alleged violation at least 14 days before the administrative hearing. Our city of Boulder practice currently is to have all those materials available at violationinfo.com, but we don't necessarily send it to them via email or hard copy. We were wondering if that is okay to just have that information on violation info to meet those requirements, because technically it is available, but it's not being sent directly. The city has a lot of these violations go to court, so it'll be a bit complicated to keep track of those 14-day requirements.
I'll let the AG jump in if I'm incorrect, but my understanding is that these rules only apply to CDOT's use. So the administrative process that we've outlined in these rules will only apply for CDOT notices of violations and then civil penalty assessments. But like I said, please feel free others to jump in if that's incorrect.
If it is for a CDOT corridor, we got approval for a few CDOT corridors that we're supposed to activate. Are we okay is the city of Boulder okay to follow the same procedures that we are following within the city, or do we need to change that to the 14-day mail or email service requirements?
Carla or Justin, do you have any comment on this?
I have a
Or
comment, and I think it would be easiest for us to actually review those procedures that you're talking about in writing before we can make a final determination.
Okay, thank you, Justin. I'll have someone forward our procedures to whoever. Okay, next question. Sorry again. There's a section that says the hearing officer shall review the evidence presented by the department and its representatives and responsible party, if any, and make a finding as to whether the responsible party is liable for a civil penalty and render a decision in the form of a hearing officer's final order. Our question was if you could clarify if this implies no court appeal, or should it be changed to that The decision shall be final for the department's purposes, but may be appealed as provided in Rule 9.07 and Section 42-4-110.5 2A 8 CRS. Sorry, that was a very long code.
Veronica, are you asking if the rule should contain the right to appeal?
Yes, correct.
I'll let Justin or Carla take that.
Veronica, my apologies for asking you to repeat the question, but I just want to I just want to hear the question again. It was a bit lengthy.
Oh yeah, no worries. Our
No
main question
judgment about it
was,
being lengthy. I just want to make sure I understand it exactly.
yes, of course. Our question was mainly to get clarification if the statement on the CCR meant there was no ability for court appeal. The sentence that's on the CCR states the hearing officer shall review the evidence presented by the department or its representatives and the responsible party, if any, and make a finding as to whether this responsible party is liable for a civil penalty and render a decision in the form of a hearing officer's final order. The question was to clarify if it allows court appeal or not.
The answer is yes. The rules do allow a right to appeal the hearing officer's decision.
Okay, thank you.
Yes.
Joe, did you want to say something?
No, that's okay. Hi, I'm Joe Van. I'm with the City of Boulder Photo Enforcement Program as well. And I'm now getting better reception on this meeting. So Veronica, you're doing a great job presenting our questions here. There was just a couple more.
Okay, next question. It's on collections. So the statement on the CCR says the department may not initiate or pursue a collection action against a responsible party for a debt resulting from an unpaid civil penalty assessed pursuant to this section unless the responsible parties personally served the notice of violation or the final order. The process the City of Boulder does, and which is what we are anticipating doing for the CDOT roads as well, is to essentially do the notice of violations twice. And if they fail, we serve them in person. And if that fails, we serve them a penalty assessment. And we wanted to ask if that is okay, an okay process for us to continue, or if we should get rid of the penalty assessment portion.
So is that for activating a collection action, or is that just for the penalty assessment itself?
For activating the collections.
If I can jump in here a little bit, just for clarification. Our program, the City of Boulder, issues 2 notice of violations. If there's failure to respond to those 2 notices of violations, either by paying or for requesting a hearing, then a penalty assessment is issued and it will be served in person on that responsible party. So that's the process in which we have it listed, and your language here indicates that we're personally serving a notice of violation, which is not what we're personally serving. We're personally serving a penalty assessment.
If I may, this is Assistant Attorney General Carla Martin. I just note that that rule states the department shall. So it starts with referencing who this rule applies to.
Okay, so just CDOT, not the City of Boulder Police Department.
Correct.
All right.
Cool, thank you. I believe those were our main questions. I appreciate everyone's time for letting us clarify a lot of them.
You're welcome. Thank you for your input. Are there any other attendees who wish to have questions answered or to make comments about the rules at this time? Please, if so, please go ahead and raise your hand.
Andrew, there's a question in the chat.
Okay. I see the question in the chat. What is the chain of custody for any data collected through the automated system? Do we have someone who can speak to the nuts and bolts of where the data goes? Amber?
I can.
Ben?
This is
Okay.
Benjamin Achimovich, the program manager. I can speak to that. The chain of data goes from Blissway or from the DO. So a license plate picture is taken, a violation is detected, that information for the registered owner of the vehicle is pulled from the Department of Revenue servers to a secured server with Blissway, and then is held for 3 years unless the violation is dismissed. So if it's paid, it's held for 3 years. After the final condition of that. So if they go to court or anything like that and they still pay it, it's held for 3 years. Anytime it's dismissed, it's deleted per the statute.
Okay. Any other questions? I see nothing else in chat. Anyone else with a comment or a question? Okay. Well, seeing no hands raised or other additional comments in the chat, that concludes the testimony portion of this hearing, and comments are now closed. I'll ask staff to include the registration list for this hearing and the recording of today's hearing in the record that's provided to the Transportation Commission. Any closing comments, Amber or Herman?
I just wanted to say oh.
No, go ahead. I was just saying no, Amber. So go ahead.
Oh, okay, perfect. Yeah, I was just going to say thank you again so much, City of Boulder, and everyone else who came to give their comments, and also to the written comments that we received. Thank you to everyone. Your feedback just really helps us understand, what issues there are, and it allows us to make changes to the rules. So really appreciate the public input. And I'd also like to thank you, our hearing officer, Andrew Hogel, and as well as, of course, Justin Curry and Carla Martin from the Attorney General's office for being here. And thanks so much to the CDOT staff for all your work on this and for being here as well. Thank you.
Thank you. All right, at this time, I make my findings that the department has met the requirements of the Administrative Procedure Act and that this rulemaking hearing has been conducted in conformance with the Administrative Procedure Act. I will grant the department's request to correct any scrivener's errors prior to submitting the rules to the Office of Transportation Safety for final consideration. And finally, I find that the public did have opportunity to comment through oral testimony and written comments at this hearing. This hearing is now adjourned. Thank you for your participation in this public rulemaking process.